Jim Crow laws date back to as early as 1865 after the ratification of the 13th Amendment, which abolished slavery across the United States. The Jim Crow laws were known for the infamous moniker separate but equal, in which the labor of African Americans was prohibited, though they were still segregated from whites. For instance, drinking from different water fountains, using different bathrooms, eating at separate restaurants, or even the fact that African Americans had to take a rigorous literacy test just to vote. The resources provided to African Americans would tend to be in a lesser quality than their white counterparts as well. In 1896, however, Homer Plessy went all the way to the Supreme Court for his argument that the segregation of blacks and whites in public facilities was unjust and deprived African Americans of their rights. The Plessy v. Ferguson case proved unsuccessful, however, as the court ruled constitutionally station barriers between whites and African Americans were legal as long as they were equal, which in today's standards they were not. This is where the doctrine separate but equal gained its nomenclature that would last for the next 6 decades.
I saw those signs that said white men, colored men, white women, colored women, white waiting, colored waiting. When we go to the theater, all of us little black children had to go upstairs to the balcony, and all the little white children went downstairs to the first floor. I would come home and ask my mother, my father, my grandparents, my great-grandparents, why? They would say, that's the way it is. Don't get in trouble. Don't get in the way.
This was no different for African Americans in the school system either. Black schools had old books, used desks and chairs, old supplies, and abandoned buildings where classes were housed. African Americans didn't have transportation to and from school either, like white children, and were often forced to take long mile journeys across railroads to make their way to school. African Americans weren't given the newest standards of teaching either, and having very few African American teachers made African American children's learning style even more difficult due to racism and prejudiced beliefs.
Because of the overcrowding, the county had built 3 tar paper shacks that sat around the main brick building.
The conditions were savagely unequal.
In the wintertime, the building was cold. Those of us who were seated closest to the stove were warm, and those of us who were seated farthest away were cold and had to sit in our coats. The building leaked in the wintertime. Sometimes the water would leak on your head or on your paper.
School books, the backs of the front torn out of it.
We had no gym. We had no lunch facility. I often wonder how we managed to finish school under those circumstances.
Black families began to get fed up with the treatment of the children in the school systems and the unjust decisions of the Supreme Court in general. Families began to take their anger out to the courts. 5 of these cases made it to the Supreme Court. The lead case was Brown v. the Board of Education, located in Topeka, Kansas. Oliver Brown, the plaintiff, filed a class action lawsuit against the Board of Education in Topeka, Kansas in 1951 after his daughter Linda Brown was denied entrance into Topeka's all-white elementary school.
Of the NAACP was to pick off wins where they could get them.
The NAACP in Topeka made a decision that they were going to try to desegregate public elementary schools. And my oldest sister was Linda, and then my middle sister Terry. They both attended Monroe Elementary School. So the NAACP instructed them, locate a white school close to your home, take your child, children, and a witness, and try to attempt enrollment, and then come back and tell us what happens. My father, following those instructions, took my sister Linda, and they walked over to the school, and he sat her in the lobby, and he went in and had a conversation with the principal. The principal was very nice, but explained to Dad that it was policy and that he couldn't enroll his daughter. That was it, and then they walked home.
Brown claimed the black schools were not equal to the white schools, and this violated the 14th Amendment. This case went before the U.S. District in Kansas, who ruled that segregation had a detrimental effect on colored children and contributed to a sense of inferiority, though the case still fulfilled the separate but equal doctrine. The 4 other cases traced within the same lines of Brown's case, which were Belton v. Gephardt of Delaware, Bowling v. Sharp of Washington, D.C., Briggs v. Elliott of South Carolina, and Davis v. County School Board of Prince Edward County and Virginia. These cases all reached the board in 1952 under the same name. Brown versus the Board of Education of Topeka. Thurgood Marshall, head of NAACP, who had been working endlessly for the rights of blacks, served as the chief attorney for the plaintiffs.
We do believe that this decision in itself will encourage the people to take further steps without litigation in many areas. And that's what I think is important for all of that.
At first, the justices found it difficult to rule on school segregation, with current Chief Justice Fred M. Vinson holding the belief that the Plessy verdict should still stand. However, in September of 1953, Vinson died and was replaced by Earl Warren, the governor of California. Showing much political skill, Warren succeeded in a unanimous vote in favor of ending school segregation. The decision, issued on May 17th, Warren wrote that in a field of public education, the doctrine of separate but equal has no place, as segregated schools are inherently unequal. As a result, the court ruled that the plaintiffs were being deprived of equal protection of the laws guaranteed by the 14th Amendment.
On May 17, 1954, there were signs. Some of the justices' wives showed up. Some clerks were tipped off. Then reporters rushed the courtroom.
Warren starts off in a bland manner, and you can't tell for a while as he's delivering the opinion what the outcome is going to be. And then he comes to the key line and he says, "And we unanimously hold that separate but equal has no place in the Constitution." And it was just electric in the courtroom when he said unanimous.
On May 17, 1954, Jim Crow was officially abolished, and the separate but equal doctrine was no more. Brown versus Board of Education changed the life historically for many African Americans, as well as serving as a catalyst for the civil rights movement, raising the awareness for racial inequality, and pushing the Supreme Court to have more racial fairness in many cases, as well as adding African Americans to the Supreme Court board, such as Thurgood Marshall.
They are the youth of America. They're all equal in the eyes of their country. In planning for public education, Americans have sought to give every youngster equal opportunity.